to this morning. So with that then, want to open the hearing on Senate Bill 398. Which is requiring a proponent to demonstrate that it is more likely than not that certain specialized knowledge will help the trier of fact to understand evidence before certain qualified witnesses may testify. And with that, a brief from the revisor.
Thank you, Madam Chair. Senate Bill 398 amends KSA 6456. This is the statute relating to testimony in the form of opinion or inferences. Current law provides that if scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue, a witness who is qualified as an expert may testify in the form of an opinion or otherwise if the testimony is based on sufficient facts and data, it's the product of reliable principles and methods, and the witness has reliably applied the principles and methods to the facts of the case. This bill would modify that provision to provide that a witness who's qualified as an expert may testify in the form of opinion or otherwise if the proponent demonstrates to the court that it's more likely than not that the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. And then the remaining three, the testimony is based in sufficient facts or data, it's the product of reliable principles and methods, and the expert's opinion reflects a reliable application of the principles and methods to the facts of the case. And I can take any questions.
Great, thank you. Committee, any questions? Not seeing any. Thank you. Then we will hear from proponent conferee Eric Stafford, Vice President of Government Affairs, Kansas Chamber. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and committee members. Eric Stafford with the Kansas Chamber, and appreciate the opportunity to be here this afternoon in support of Senate Bill 398. I am honored, flattered, and humbled that so many people were willing to come listen to what I had to say this afternoon in the audience. Yeah, we introduced Senate Bill 398 this year. Kansas is one of the states that has our expert evidence standard in statute. So that was first put in place back in 2014. This morning we heard about non-economic damages. Back in 2014, there was a bill that raised non-economic damage caps before they were ruled unconstitutional by the Supreme Court. But there were components in that were from the coalition side. It was the healthcare community really leading that to try to ensure constitutionality of our caps, which obviously didn't work out in our favor later in 2018, 2019. But to offset the increase in caps, there were several what we considered fair and reasonable tort reform initiatives paired with that. One of those was adopting what is known as Federal Rule of Evidence 702, or the Daubert standard, compared to what was the older Frye standard. And in December of 2023, the federal court system updated their expert evidence standard. And so the states that have them in rules, they're adopting them in their rules. The states that have them in statute, they're adopting them in statute. Missouri, I think, had a hearing yesterday or maybe even today on a very similar bill for their state to adopt. Theirs is in statute as well. Several other states that I listed in our written comments have gone ahead and adopted the changes to match the federal rule change. So really, in our view, this is just a modification to continue to mirror the federal standard, but since ours are in statute, we have to update it. So this was brought to our attention as a change. Again, December of 23, those rules were changed, and this got brought to our attention to bring this session. So would be happy to answer any questions. Again, it's in our view technical in nature. I think the fact that some of folks that might not necessarily agree with us on legal reform initiatives are not here. I think that they're in agreement with the language today. So, but happy to answer any questions. But in our view, this is just a statutory cleanup.
Thank you. We'll go ahead and reserve questions till we hear from all the proponent conferees. So,
sure, thank you.
if we do have Pamela Brocker on behalf of the Kansas Motor Carriers Association and the American Trucking Association on WebEx.
She was going to have to be written only this afternoon.
For this afternoon. Okay, great. So she's written only. So, Eric, unless we have other conferees wishing to testify as proponents, which I'm not seeing any. That's you then, so great. Any questions for the conferee? Not seeing any, then want to bring to your attention, we do have proponent written-only testimony from Dan Murray, Kansas State Director, National Federation of Independent Business, Tyler Heffron on behalf of Kansas Association of Defense Counsel, Peter Conley, Deputy Capitol Defender, Board of Indigent Defense Services, Marley Carpenter, Kansas Association of Property and Casualty Insurance Companies, Katrina Abraham on behalf of the Greater Kansas City Chamber of Commerce. And do we have anyone wishing to testify as neutral? Not seeing any. Anyone wishing to testify as opponent? Not seeing any. Committee, we do have opponent written-only testimony from Travis R. Aller, DC, Executive Director, Kansas Chiropractic Association. With that, then, we will close the hearing on Senate Bill 398 and thank everybody for stopping in this afternoon for our Judiciary Committee meeting. Please do have your amendments ready. We do intend to work bills previously heard, so we'll do that next week. And if your hearing is on Monday, February 9th, please make sure to get your written copies of your testimony in to our committee assistant by 10 a.m. tomorrow, Friday, February 6th. Thanks very much, and with that then, our meeting is adjourned.